Should the driver be charged with driving with drugs in their system or driving under the influence of drugs? That's the question in a case at Kurri Kurri Local Court. Police chose to charge the driver with driving under the influence of drugs, which I understand is section 112 of the Road Transport Act, which for a first-time offence risks 30 penalty units or jail for 18 months or both. Police must prove that they were under the influence. I think this might be a bit tricky in this case. We hear the police observed the driver having 2 phones on their lap and was fidgety. Plus the driver admitted to doing ice, meaning meth, and cannabis to police. But the police didn't do a roadside test or a blood test. So it's just the driver's admission and the fidgety observation from police. The driver, who has a defence solicitor, pleads guilty. But wait for it, the magistrate refuses to accept their plea and goes on to explain there's no blood analysis. And words which I take to mean that the observation of fidgety isn't enough to be charged with driving under the influence. That's just my interpretation. The police prosecutor is questioned about the charge. Discussion moves to perhaps a different charge of driving with the presence of drugs, which is section 111 of the Road Transport Act, and I understand is a fine-only offence of 20 or 30 penalty units. And yes, it would be the driver's admission that there was a drug in their system that would be the evidence to prove the elements of the offence. It's what they said to police that's being used to charge them, which the law allows. I'll let you process that. So what happens next? Well, the police are going away and deciding whether they'll change the charge. And everyone will return to Kurri Kurri Local Court for the next mention in November.